In this video, we are going to discuss about a popular trademark case between the two giant companies from India, which is none other than Indigo versus Mahindra and Mahindra. In this case, we are going to see the three important aspects. One is the importance of trademark search. Second is the importance of the trademark rights. Third is the brand identity. In November 2024, Mahindra and Mahindra, a giant company from India who is into manufacturing of automobiles, launched its own electric cars in the name of Born Electric, and it specifically had two brands. One is BE6E and another one is XUV9E. For these models with these following names, Mahindra and Mahindra has applied for a trademark under Class 12, which covers the automobiles. Now comes the interesting part. Another aviation company called Indigo Airlines, which is using the brand name 6E, is filing a trademark case against Mahindra and Mahindra. Now we are going to discuss what is the case update still today and what is the implications based on this case and what we have to learn from the trademark registration. Myself Rohini, your intellectual property lawyer. Watch this video till the end where I'll be sharing with you one most important point on trademark registration. Now let's discuss about this company Indigo Airlines. Indigo Airlines is a company which has 60% domestic share in the aviation industry. And it has been using the brand name 6E largely for so many decades, wherein which they are using 6E Prime and many other brands which is identified by 6E. Now they are so particular about their brand and they are vigorously searching for the brands which are being filed with this 6E terms. Now when Mahindra and Mahindra has launched their cars in the name BE6E and they also mentioned that they have applied for a trademark, immediately Indigo Airlines has filed a trademark suit against the Mahindra and Mahindra. Now this case, Indigo Airlines has filed it before the Delhi High Court. This case was filed immediately in the month of November 2024. But it came for hearing after a month in December 2024, and during the hearing proceedings, the Indigo airline actually made a claim stating that the use of the term 6E causes a confusion to their consumers who are very well identified with this term 6E Indigo. Now, on another hand, they are also saying that this is our brand identity and we have invested in this brand where many people are popular with this term, and this will definitely cause a dilution of their brand identity. In this case, Indigo seeks before the court for injunction to prevent Mahindra from using the term 6E. Now, what are the defensive arguments which are raised by Mahindra? Mahindra has stated that the consumers who are using the Mahindra cars and the consumers who are flying in Indigo Airlines are totally different and there is no room for confusion between the both. On the other hand, they are also stating that we are into a totally different sector of market and they are into a totally different sector of market, and this will not cause any confusions or brand dilution. This is their argument. Also, Mahindra has taken a stand that they will stop using the name 6E temporarily until this case gets the final order. Before even the court could give an injunction, the Mahindra themselves have rebranded their car from BE6E to BE6 so that they don't want to contest right now, but they are holding their rights to argue in this court to use this term 6E. Here we do understand there is a trademark infringement and we have to wait for the final orders, but here we are getting another discussion about cross-industry trademark use. What is cross-industry trademark use? It is nothing but when I am using a particular brand name in a particular industries, whether the same name, even though it is popular, can it be used by someone from another industry? So what is the draw line or what is the right of the person who is in the prior use? If somebody else copies in a different industry, how much trademark right actually the owner of the prior industry will be having it? We clearly know that there is a trademark infringement which will be ultimately decided, but whereas we are also raising a question of cross-industry trademark use. What is meant by cross-industry trademark use? Actually, I am using a particular brand name in a particular industry, let's take for a healthcare. But certain other persons or certain other business owner may use the same trade name for another industry which may belong to a food industry. So when it comes to this kind of usage, what is the right of the prior user? What is the right of the other person who is using in a different industry? Now, high courts have to give a clear view on this point through this case. As of now, in December 2025, in this particular case, since the Mahindra has accepted not to use the name 6E by themselves, the Delhi High Court has issued a summons to remove the name as well. Also, the Delhi High Court has posted the hearings of this case on April 2025, and further we need to wait for more updates from this case. This particular dispute has underscored two important aspects. One is how it is important to make a trademark search before you apply for a trademark registration. Number two, as an entrepreneur, you must have a clear branding strategies where you thoroughly verify whether your trademark is used across the different industries. We should also understand in this process that well-established popular companies are vigorously monitoring and they are trying to protect their trademark and want to maintain their customers' trust. So if you are trying to use any popular company's brand name from India or from overseas, you will definitely face a trademark infringement suit. For that reason only, we have always been insisting that choose a brand name which is unique, which is coined by you or which is coined by some other reasons and not from the popular names. In this particular case, Indigo has raised a suit against Mahindra from stop using 6E. I want to know your opinion whether Indigo is taking a right stand, or if you also feel Mahindra should continue using it or Mahindra should stop using it. What should be the court's view? I would like to know from you. Put it in the comment box. Let's read your opinion. Myself Rohini, your intellectual property lawyer.